Yes, Mr. Talda.
My lord, in respect of item 5, your lordship was pleased to time for reconstruction of the files, my lord. And that was listed before the vacation. Immediately, I applied the certified copies, my lord. But the filing section has informed that due to the intervening holidays, my lord, it could not be, my lord, made. My prayer is, my lordship, make an observation so that your lordships can take up the matter next week. My lord, I have applied, my lord, this is the documents, my lord. On 24/9, I have, kindly see, my lord. On 24/9 itself, I have applied.
A file to talk video. A file to video. You go through it. We'll help you. You go through it.
It's a
Stay. There are two accused. We don't know what happened to the second accused. Sarifuddin, from whom you have purportedly procured for 15,000, the appointment letter. The appointment letter was produced by you before the director. They found that the thing is not genuine. So, forgery 420. This is an offense of long back. Try to convince me that I take a lenient view in the matter.
Can I, please? Or she will make it part her, take up on Friday, Mal. At least I should go through the documents.
You just go through it, Mr. Talukdar. Get the intention of the court. Go through it. Then we will see. Something. File to review. We'll take it up as the last item.
Simple hard. It's a different part of
Joinul Haq.
Joinul Haq.
Sounds of 5%. Oh, this is that student assaulting the teacher. Sorry, assaulting the teacher, and that aspect that he was expelled, and then the marpit is established. The handyman and the driver. You have not gone ahead and examined them to the aspect as to whether the marpit was inside the bus or outside by some others. You are projecting that it was a fight between the passengers per se, not about this. There were 4-5 people. Only the accused was. Go through it. We'll see.
Number 6, lordship.
Hmm.
Can it be taken up at 2 p.m. lordship? I have to go through the record. On the last day, lordship, I have got only the memo of appeal. At 2 p.m.
Okay. Our last item. This is as last item.
May it please, my lords. My lords, may I pray for the listing of an anticipatory bail at 2, my lord.
Today.
My lord, yes.
What is the urgency?
Apprehension of arrest, my lord. There is a civil dispute.
Take it tomorrow morning.
The first item, perhaps, then, if it's possible.
Tomorrow morning. Tomorrow.
Lordship, 10th Lordship, I have already filed on 9th of October.
All allowed.
Let it tomorrow. Another application is there, Lordship. One criminal application. 2 times I have taken his test, but the respondent.
That you will, criminal appeal, you take it after a few days, but this bail we'll take it up tomorrow itself.
Then 22nd.
Whenever convenient.
May I please, Lordship? Lordship, yesterday filed a adjournment slip, Lordship, regarding the item number 12, Lordship, due to the medical ground, Lordship.
That was filed by respondent number 10.
Yes, Lordship.
Name, counsel?
Counsel, Lordship, P. Hazarika. I'm on behalf of P. Hazarika.
A prayer is made on, he is having some personal medical emergency.
Brother is hospitalized, Lordship.
Okay.
Fine.
A prayer is made on behalf of Mr. P. Hazarika, learned counsel, for the respondent number 10.1 for an adjournment in the matter on account of certain personal inconvenience. Prayer is not objected to by the learned counsel for the petitioners. Also, accordingly, registry to list this matter again after when?
Last week of November.
After 3 weeks on a date to be fixed by it. So the matter be not treated as parted and or tied up matter with this court any further. Done. Yes,
So,
madam.
I beg to mention for listing
When?
May
দি দিয়া
please-
এইকেইটা। খালি সেই এটা অৰ্ডাৰ্ছত কিবা এটা আছে না, সেইটো 22 তাৰিখে দি দিবা। Yes,
May I please, Your Lordship, I beg to mention on criminal petitions for listings on 29th October.
may please, your lordship, I beg
Like to mention for listing,
records have come.
like to mention for listing
When? কাগজ এখনত লিখি দিলে হ'ব।
Senior is at Lexet code number 3. Can it be taken up after some time?
Mr. Day, PC Day.
PCD.
The 498A is established. What about what do you find about the pouring of the kerosene and the victim statement is fine, but the other statements,
Independent witness one.
they say that they opened, the door was closed, they opened the door
Yes, PW2.
too. So if that be so, what would be the effect of the appellant pouring there is a doubt that it could have happened from the kerosene lamp that was besides the bed. What do you find in that? You go through that. We'll take it up, go through that. This aspect only. 498A, they have also not pursued the matter for
Within 7 years of her marriage.
one and the 1 lakh demand.
Yes,
They
demand
have
is
not
there.
pursued the matter with the witnesses in the manner required. But with regard to the burning, there is a doubt. You just go through that.
Yes, I'll go through it.
Mr. Islam is there. Yes, Mr. Islam. Love went sour.
Yes.
Huh? Okay, in 313, you have taken a plea that there was a love affair between you and the girl. Why this was not pursued with the witnesses?
That's the problem, my lord.
That's the problem, means that's the problem
Now,
now.
one thing here is this, the witnesses that are examined before the court below, all are contradictory statements has been made.
There are two witnesses who are her friends.
Yes.
They have deposed with regard to the kidnapping of the girl by the accused, by the petitioner appellant herein.
Definitely.
Appellant herein, and that is not dislodged. That corroborates the evidence of the victim.
But one thing,
Hmm.
can you see?
I want that
the
one thing
statement-
only.
Statement from the victim,
Hmm.
it has clearly stated, she along with Jintu Ali
Hmm.
and the Begum,
Hmm. One
they are
Begum,
going
huh?
wed,
Moni Begum.
Moni Begum. But in the
Evidence it is
Evidence.
Riazur Rahman. That's
nowhere
forget
mentioned
Jintu, forget Riazur.
bus.
But Moni Begum's evidence is there.
W3.
Moni Begum evidence is there.
What do you say?
But now the question arises whether this is a wrongful confinement
And you
or forcefully taken her in the auto rickshaw.
that
That
where is the material?
Because the petition, the.
You
was
only got
punished-
to, you had to only establish that it was not forceful, it was consensual.
Yes,
How have you done it? Except your 313 statement.
Except 3-1, but the conduct of the witnesses herein. Witnesses said that the appellant has came when they were going to their tutorial home. At that point of time, the appellant accosted them and have her in a auto
Hmm.
forcefully and taken away in unknown places.
Hmm.
But now,
So the minimum
After that-
penalty has been.
after this such type of incident,
Hmm.
the witnesses went to their tutorial home after completion the tuition. Then only they reported to their parents. If such incident was happened on the road at a daylight, had it been done by the appellant, then the witnesses
Conviction is under 365
365, not 360, 366 not proved.
because she is a major.
Yes. And these another witness said that the incident was happened after.
How
coming
many
back
days
from
were
the-
you behind the bus?
All days all along on the bail. Yeah. And the two witnesses also clearly stated that they knows the appellant, these independent witnesses, meaning thereby they knew the fact that there was an love affairs in between the him and the appellant. So that's why they did not make any hue and cry. Also, all along bail. Record. And another thing, the statement made under section 164 CRPC
Hmm.
and the
What is there in 164?
164, she said that forcefully taken her and thereafter forcefully
That
married
rape
her.
is
Yes.
not said when the
Yes,
in the deposition.
yes, nothing has been said.
But forceful taken away, that is it, my lord.
And if, because this under section 365, there should be a secret wrongful confinement. That is so, then the petitioner taken.
When
her-
was the FIR filed? Immediately.
I filed on, yes, immediately, 7/2/09, immediate.
FIR filed on 7/2/2009,
Incident is also of 7 to
7
2000.
7/2/2009. Charge sheet has been filed on 33/2009. Charge frame under section 366 IPC.
Yes, what is your ground? One.
But my first ground is that
Hmm.
there is a huge contradiction in between the
What is the contradiction?
first one, the PW 3 and 4.
Hmm.
W3 said that the incident was happened
Hmm.
when they were proceeding to their tutorial home.
Hmm.
And the PW4 before the police, he stated that the incident was taken place after coming back from the tutorial home. And that's corroborated.
No, PW4.
PW6.
PW4
Yes.
said that that is while going to the tuition classes on foot.
But kindly see the PW6. Rose. The police.
Going on foot to attend.
Police, he stated before the court that Riyazur Rahman told before him that the occurrence took place while he was returning from his tuition class.
But the PW4 was not comforted with that statement.
Confirmed, my lord. In cross, my lord, I am just reading.
Hmm.
It is not a fact that in my statement, I have stated that the incident took place while we were returning from the tuition class. Confirm what is stated in the chief.
Oh, in cross examination,
What happened to the girl now? Married?
girl already married, subsequently married.
Boy?
Boy also married. And in PW3 also stated in the cross that it is not a fact that accused possibly took.
What does the boy do?
Boy is a driver.
He was driver of the
I know that after now, presently.
Presently, he has done some works. I have contact him.
Yes, Mr. Goswami.
evidence, my lord. I don't find any.
No, one factor.
Lordship.
A girl says that she was forcefully kidnapped. She continued from the place of kidnap till the house of the boy
Lordship.
in the auto rickshaw without even any hue and cry. Right? She was in the house of the accused for around 3-4 days. No hue and cry raised. So does not that not give a rise to a doubt that this was a consensual act? Because 313 statement of the accused is that they were in love. Although he did
Yes,
not pursue
yes,
that.
Yes.
He did not pursue that with the
Yes.
witnesses.
They know each other. That might be a fact because he is the driver, my lord.
Because that element that with the intent to cause that person to be secretly and wrongfully confined, that somehow is doubtful. Incident is of 7 to
2009.
7 to 2009.
$16. We'll give him the benefit of doubt.
Yes, my lordship is not. So far, I think, my lord, PW 3, 4, my lord, their evidence is very intact, my lord. My lordship, if your lordship may go through it, my lord. Said that attending tuition, Bobita was also with us about 3 years ago. While
And they also did not, they also, it was Conal Sivaram Borapur, just behind my lane. And that's a very busy place. If this has happened, they have not even raised a hue and cry for that.
And thereafter, they went to the tuition. Completed the tuition, thereafter only
They are serious students. That is why 16
Right,
years
yeah.
afterwards, nothing is there. Because these two factors gives rise to a doubt. I think that should be answered in favor of the accused. And after 16 years, what left this case?
regarding all
We'll
recorded,
look.
my lord. Yes. Statement of the 164 and victim. my lord,
164, she diluted that during her in the deposition in the trial.
Yes, but the fact remained, my lord, that she was with the accused. my lord.
Then it should have been 366, not 365. You should have come up on appeal. Then the ingredients of 366 would have been established, not 365. Right?
That my lord, because measure that is why.
No, major also woman, na? Those 366 ingredients were we give him the benefit of doubt. Disposed of. Yes, Mr. Mahmood.
Lordship, I am for the informant, Your Lordship.
Hmm.
My prayer for password the matter for the day, Your Lordship. I have already misplaced the file due to shifting of my chamber, Your Lordship. Any date next
Fine,
week, Lordship.
fine. You take help from the PP file.
Can be taken after some time, Your Lordship.
After some time,
Objection of my senior. Lordship.
provided the senior is consenting. We can't keep Mr. Mahmood waiting for the whole day.
Your Lordship.
12 o'clock. Done.
Oblige, Lordship.
This is that biting incident. That
Yes.
biting incident.
List.
But you broke open the door also. Evidence is there. And that medical examination was done after quite some time. So that teeth marks may not be there. Because it gets
That
bluish
creates
and
doubt.
all.
That creates a doubt.
It does not create a doubt. But the injury is there in the right hand. And you have not brought on record anything. The conviction is under
76 450.
No, 376 is not there.
457.
354 and 457. Lurking house trespass and attempt to outrage the molesty. Right? And the lady was 7 months pregnant at that point of time.
457, 376, 511.
511. 511, okay, fine. It's okay. But the thing is, you are found guilty under 457 and 354. 457 materials are there. 354 outraging the modesty. The lady was 7 months pregnant at that point of time. And it is that lady you went and expressed your love.
Otherwise not believable.
How?
9 months pregnant lady,
7 months pregnant.
10 months.
But people lose their sense. They don't think about you had great love with her. You wanted to express the love, taking the advantage of her absence of her husband.
This is a very old case, my lord. I have brought some citation on that point.
Old case is Mr. Mahmood has also not pursued this matter. Last it was listed in 22. Before 2019. And then it is all 2014.
Other party has taken adjournment.
Appellant.
Mainly.
Appellant.
That's to
Appellant. It's written appellant. Okay, let him prepare.
yes, at 12.
12. Madam Bora, have you gone through the... Yes, Mr. Soma.
My lord, under section 420.
Oh, Vodafone.
Vodafone. But
Your husband's witness signature in that compromise memo. You have not demolished that.
yes, my lord, whether my lord did exhibit 2, that compromise can be treated as an agreement or promissory. My lord.
No, not a promissory. It is one of the incidents circumstances which shows your intent.
But my lord, the.
But that was exhibited, but you did not demolish that.
But my lord, in my 313 statement, my lord, that my lord I have annexed, that
Hmm.
was my lord under force or coercion, my lord. That my lord, the 313 statement, lordship will find that.
Okay, fine. Force and coercion, I accept that. Where is your persuasion of the witnesses with regard to this aspect of the matter during their cross-examination? You made a statement in 313, fine. But when the officer in charge had come in, when the other persons were making their deposition on this aspect, what is your cross on that?
What is missing?
Ah.
But my lord, one thing, my lord, here the basically the allegations is as regards the recovery of money. To take recourse of the my lord criminal proceeding, my lord, instead of filing, my lord.
Not the recovery. Recovery is
Recovery, my lord.
confidential.
Yes, my lord, recovery.
Here, you have been found guilty under 420.
Yes.
You made her part with the.
Because the complaint has been filed, my lord, under section 420 and 406. 406, my lord, the trial court, my lord, is not found anything, my
no,
lord,
no.
and convicted under section 420.
Because there was no entrustment of property.
Yes,
But 420 ingredients are proof.
but the PW1, my lord, the complainant, my lord, herself in her depositions, my lord, specifically stated as it is as regards, my lord, the recovery of money only.
Oh, that is her statement. Because recovery means that she had parted with something illegally.
But,
You had,
but my lord, that amount, the 40,000, my lord, has been.
that is by check.
By the husband.
Fine. Fine. On her behalf.
But the
That was seen in your account. That check came to your account.
Yes, that is
So,
true.
the fact that you had approached her for setting up of a Vodafone, that is established. The second part is also established. What do you say? Money has been repaid? No.
No, as far.
Money repayment or not, that is not the concern of this court. This is the concern is 420. Cheating, deceiving.
Sitting.
So there is, you are not, have you shown somewhere that you are an agent of Vodafone? Then, madam, you are appearing for? No, you are appearing for whom?
Informant.
See, informant is up and going.
My lord. My submission is, my lord, that it's a, my lord, recovery of money. It's a civil nature, my lord. And secondly,
That's
my
not
lord,
civil nature. Every 420 case would be a case of civil nature then.
so far the recovery part, they may, my lord, otherwise, my lord.
The recovery they want to do, they will do. But we are concerned with the 420 only here. Cheating.
Secondly, my lord, that the agreement, that exhibit 2, my lord.
That also
Agreement
that
between-
is only a factor. But you have not pursued the, have you questioned them, confronted them with those questions? That this was done under coercion, threat. Nothing.
PW4.
You have examined him in that light.
Yes,
You have examined him.
I have crossed, but that part.
That part is not there. So, Mr. Sharma, how do you come on? Who is here, counsel? We'll wait for Mr. Medi. For some time.
Or my lord,
No, not today itself. I have read it. I'll forget it.
because my senior is leading, my lord, that's why.
Your senior is Mr. Monto. Oh, you are enough. Mr. Monto is too busy. If Mr. Monto comes also, fine.
No, my lord. I'll.
After some time, call him. Yes.
Your Honor, the concerned for the petitioner is currently out of station.
Can't help it. Not accepted. You argue.
I,
How long have you been in practice? 1 month. Now we'll initiate you into the practice. You have the brief with you? Why? Brief is kept in under lock and key by your senior. Who is your senior? Huh?
Ali sir.
MK? His name is not shown here in item number 11. Huh? Asani. Oh, MK Ali. Huh? When did he go out? Then why did you not make a mention memo yesterday for adjournment?
Sir, we had gotten the message yesterday.
Oh, you're not with your senior?
Right now, sir.
Then forget it. Then you don't appear. We will consider. Yes, Mr. Sharma.
471, my lord, that is.
471, he was
against the present
acquitted, but
petitioner, my lord.
417 and 417,
471, my lord.
no, he was, okay, 471. But in the appeal, the punishment was modified to 417, 511. What happened to the other accused? Sharifuddin? Saifuddin.
Perhaps he is under 468, my lord. Convicted under 460.
Four 68.
My lord. Last page of the.
Then what happened? He has undergone his, any appeal filed by him?
My lord, no knowledge.
What is the material available to show that this boy, he knew that this was a forged document? Any material? He had got this from
Yes.
that Saifuddin.
That
It
later.
might be under the bona fide belief that this is okay. This was an incident of
2002, my lord.
2002.
Oh, my lord.
Hmm? So, the boy's life is otherwise also finished.
Hmm.
Hmm?
My lord. After such a long time, my lord.
Okay. What is your name? Huh?
Benjamin Singh sir.
Benjamin? Benjamin, right? S-I?
NG S
S-I-N-G?
SIT. SIT.
S-I-N-G-S-I-T. Singhjit.
Singh sir. Yes.
You are appearing for Mr. M.K. Ali. Okay.
Well.
Okay. We are not sending him to jail. We are giving him the benefit of Probation Offenders Act. You tell your senior that you have successfully done that. And next time I see you in my court without a file, you will be in trouble. Yes, Mr. Ajika.
Before I proceed, I have lost you. I am sorry to say I'm little bit handicapped by the fact that our file was misplaced. On last occasion, my current friend has mentioned that depositions are with me. Still, I made an effort to go through the record whatever I have, my lord. I will after taking the judgment from here. Deposition without deposition, feel lordship to hear the matter when otherwise.
Yes, yes,
I need
yes.
some
14
time
matter,
to
we
do
are
the
not adjourning.
deposition. I'm not asking for deposition. I only want.
This
to go
was
to-
that case wherein during Shahri time, the girl was.
Yes, yes, yes. Here, my lord, what I have gone through, my lord. I was like the consenting most probably, my lord, because she never raised any hue and cry. Her mother saw her at the time of taking her away.
That is what I think I told Mr. Amit.
She also did not raise hue and cry. Then she remained in the house for 4 or 5 days, my lord, and she was moving freely. There was no obstruction to her, and nothing was done wrong was done on her also during her stay. Also, she was for nothing, my lord, that she was confined or any harm was physically was caused to her, my lord. And apart from that, my lord, this is a case, my lord, where the 366 for to attract the ingredients of 366A, my lord, that ingredients are also not there. See, but if you also go to the section of 366A, my lord,
Hmm.
we clear that from what is materials that will produced by the prosecution, my lord, this is not attracted, my lord. There no such allegation is there, my lord, as I have seen, my lord. Plus, you've got email. See, whoever, may I go to email? Read it, my lord.
No, I'm going to.
Must be, my lord, induced or forced to induced.
What happened to Ali Hussein? Ali Hussein, the co-accused.
No, he was absconding, but later, my lord, I don't know. He was
also sentenced.
sentenced most probably, my lord. Initially, he was absconding, my lord. The sheet against it's charge sheet filed against Ali Hussein also, my lord.
Hmm.
Not showing Ali Hussein as absconder.
Hmm.
What is my lord? Both
The judgment. Last part.
yes, Ali Hussein and Zainal have been found guilty under section 3. We were convicted, my lord. Other two are, my lord. At that time, my lord, when the occurrence occurred, it was a Sehri time. Your team knows that at the time of Sehri, my lord, people wake up in the Muslim people, my lord, wake up for takes my food, my lord. It's a Ramzan month, my lord. And many people were moving around in the road, my lord, for going to the mosque to pray, my lord. See, if she had raised you and cried, it would have attracted those people, my lord. All these things implies that she was a consenting party and she stayed there for 4 or 5 days, my lord. And moreover, but her age is also not proved, my lord, that she was below 16 or below 18, my lord. That is the essential ingredients, my lord, of under 366A, my lord. Must be below 18, my lord. So no document is produced, my lord. I've also got some decision I will produce. I will give the lordship, my lord. Because of some paucity of time, and I could not, but I have taken note of it, my lord. Doctors, as per doctor opinion, my lord, she is around 15, 16 years.
Around-
2 years
around
error is
15,
taken, my lord.
So she is a minor.
2 years error is taken, and she is 18 years. my lord.
Then that can be either way.
Doctor's opinion, my lord.
Either way. 2 years can be in either way. To 18
Yes, either way,
I can
normally
take it,
is,
minus
second-
2 also.
higher side is taken, my
No, no, no. I can take it minus 2
Minus
also.
12. But
It's just an
normally-
opinion.
Yeah, yes,
But the
opinion.
girl's own statement is that she is
But since there is
14,
no,
15 years.
her own statement is, but apart from that statement, I won't
My lord,
do, my lord.
injury is also there in medical report.
No single independent witness examined, my lord. All the family.
The injury hymen tear is a old one.
Full one. That part is not taken into consideration by the Lanat court below, because that part
The only thing is the girl is a minor.
that minor is not proved, my lord. Her age has to be proved by documents, my lord, or either or through radiological examination, my lord. But that radiological
That is
opinion is
JJ.
there is not conclusive, my lord. It is an opinion, my lord. She has rightly said, my lord. It is an opinion, my lord. She was studying in class, some minor. or 7 like the my lord.
Then,
Eight, my lord. So she
then
must be 14.
that is also a
The
factor.
documents, school documents, they could have produced, my lord, that to prove that. I also did not make any attempt to collect them, my lord.
And you have
Documents,
not
my lord.
comforted her with regard to her age. In
But
your
It
cross.
must be there, my lord. Still confident, even not confident, but that is if the prosecution fails to do it, or even the defense fails, but that must be there.
Okay, what are
Nothing-
the decisions you want to rely upon?
I have not, I will rely, my lord. The lordship may see that this case is a case of consenting, but she stayed there 4 or 5 days.
But consenting when it's a case of a
She was
minor,
not confident.
that will not come in.
No, minor is not established, my lord. That is, because just by a statement cannot be enough, my lord. Either school certificate or birth certificate or this is or by radiological examination, my lord.
That has been dealt with.
In our own High Court, my lord, that's one decision is there, but I have not got it now, my lord. I will give the list, my lord, to lordship later on, my lord. If not possible.
Today we wanted.
On age, my lord.
We'll have it
2000
at 2 o'clock. You get the decisions.
At 2 o'clock, my lord. Otherwise, it's a case of clear case of acquittal, my lord, because my lord, she was never raised any alarm, nor even by my mother who was witnessing the whole incident.
Mr. Sharma.
These are main points, my lord.
I'll go through.
The minor part, we keep it aside for a second. The girl was kidnapped in the front of her mother. Mother does not raise any objection, any hue and cry. She permitted, literally. The girl was in the house of the boy. Evidence is that she took her bath there, food there, stayed there.
The House of Joinal.
Now, in that view of the matter, the mother not objecting,
Objecting.
the girl not raising a hue and cry, leaving the minority thing aside, what do you have to say? Just go through the.
My lord.
One more thing, my lord, I want to point out, my lord. That matter was brought to the villagers also.
Picture was there, but nothing
There
happened.
was election changed here, but no village, and none of the villagers were examined. At least some of the villagers.
You
one
could
or
have,
two-
you could have brought them as your witnesses.
But is it due to the prosecution?
They have brought their best
Because
witnesses.
Because
They have brought
non-examination,
their best witnesses.
lapse on the defense cannot be a ground for
Lapse on the defense. Where is your stand? In 313 also, what is your stand?
Actually, I not
Go
found it.
Go through. Go
But anyway, that was maybe denial, maybe there, my lord.
Only
First,
denial, no
prosecution has the-
explanation.
There are two views, but in this case, my lord. One the view that is favored in case of the.
No,
There are two
that
views in
view
this case, my lord.
is subject to the condition that the girl is held to be a major. Otherwise, minor consent is nothing. It's of no use.
But the age is not established, my lord. Still,
We'll
can
see.
go to
We'll
that.
see. You come with your decisions.
Except the medical, my lord, which
You
is the.
get your decisions. We will see.
Yes,
And
my
the
lord. I will-
doctor was also not comforted by you on this point.
On this, but he said
You
that he's-
permitted that evidence to go on record.
No, 16 years he it had to go.
So we'll
that
take it.
error part, my lord.
We'll take it at that only,
Normally, the
within that range only.
precedent is that, but normally the higher range is taken because if 2 years is, yeah, that is the
Give me,
precedent, my.
give me,
I will
give me.
At 2 o'clock, I will.
Yeah, matter. however.
And it's the old case, my lord, that's we can consider on that aspect also, when occurrence also a very old case.
In a case where it requires such consideration, we will provide that
Can
consideration.
consider that part also, well, it's a very old case now around occurrence,
Yes.
my lord.
No new council has been appointed.
But one more point, lots of, but that's, I have that one, was that inducement for marrying her or to have illicit.
That is
intercourse
not there.
with that section, that part is,
That
that
is
is the
not-
main ingredient of the section.
That is not there.
She has to be.
Okay,
induced
structure
to-
it with your decisions. Get out of that minor thing first.
The minor, even after that, but that section must be satisfied, my lord.
Okay, we'll come to
That
that.
section without.
We'll come to that, Ms. Vazirika, but take this court out of that issue first. 15, 16,
Minor, my lord, but that,
15, 16 plus 2.
yes, that is to have, even if she is minor, my lord, but that, the other part must be also satisfied, my lord. That
We'll see.
she is induced to marry or have illicit intercourse with
We'll
other
see.
person.
At least then, if
That part
not
is
that,
not.
365 would come in.
That 66 can come, and that is, you'll also correctly say that, or 65 or 66 also. down.
366 or 365 can come in. We'll see. And we have the power to convert. So you prevent me from
But I
doing that.
still-
You prevent me
That
from
will
doing
not
that.
go to that aspect, my
You
lord.
prevent me from doing that. Money, check amount paid. none has appeared for the petitioner on call. Who's up? Mr. B.P. Sinha, learned counsel for the respondent complainant, is present. For the ends of justice, this court appoints. Yes, who will volunteer? Can I act? Can I act? Yes, come on. Mr. A. Ahmed, learned counsel, present in the court on being requested, has consented to act as the amicus curiae on behalf of the petitioner in the matter. Accordingly, a registry to list this matter on Friday, reflecting the name of Mr. A. Ahmed as amicus curiae in the matter. The appealer, Bona Kennedy, she'll give you a copy. Yes, what happened?
Lordship, in pursuant to the last order, department has communicated yesterday, assess the errand, Lordship. 20,400.
Have you deposited this amount?
Yesterday, I have received this, Lordship. I will pay, Lordship. 10th of October.
Where is the agreement for you? This was just
States of commercial sets that I have been possessing. Already, Lordship, some other come to occupy them. Have the place in the
who is appearing for the industries department?
and was appearing on last occasion.
Mr. D. Kolita, learned counsel for the petitioner, in pursuance to the directions passed by this court wide order dated 10/9/2025, has submitted that the petitioner had approached before the General Manager, District Industries, Roman and Commerce Center, Tinsukia, for determination of the rent of the shed occupied by him. So, in terms of the said application made by the petitioner, the General Manager, District Industries and Commerce Center, Tinsukia, has determined the rent payable by the petitioner for the period October 2014 till January 2022, and at amount of rupees 20,400 bracket of 20,400 has been determined for the purpose. Also, Mr. Kolita submits that the petitioner would pay the said amount as determined in his case on or before. Or give me a date.
Seventh of November.
On or before 7/11/2025. Full stop. As none has appeared for the respondents, Mr. D. Kolita, learned counsel for the petitioner, shall furnish a copy of the communication dated 14/10/2025 to the learned counsel representing the respondents. Also, the learned counsel for the respondents shall also receive their instructions in the matter. Also, registry to list this matter again on 12/11/2025 for further orders. Also, a copy of the communication dated 14/10/2025 as furnished by Mr. D. Kolita is kept on record and marked as X for the purpose of identification. You give a copy, take a receipt of that. 7, not yours. Yes, why is Mr. Day being delayed?
My lord, he's at court number 3.
Matter is going on. How long will it take? Okay, we'll take it up after some time. Well, let Mr. Day go.
Standing 10.
My lord, that exhibit 2 part, my lord, that in the cross examinations, the PW1 and PW4, my lord, that question had been put, my lord, as regards force in execution of exhibit 2.
Where is that?
That in the cross examinations of PW1 and PW4.
PW1 and PW?
4.
Yes. Yes, Mr. Ahmed.
It has been denied, my lord. সত্য নহয় যে মই ভয় ভাবুকি দি পুলিচৰ হতুৱাই উক্ত চুক্তিপত্ৰখন আসামীৰ হতুৱাই কৰি স্বাক্ষৰ কৰো. This is the PW1. And in the PW4, my lord, that is the
4 is the police officer
Yes.
investigating.
Yes, yes. But, PW4, my lord, মই উক্ত চুক্তিপত্ৰত স্বাক্ষৰ কৰো, কিন্তু তাৰিখ পাৰ হোৱাৰ পিছত আসামীয়ে টকা নিদিলে. টকা নিদিয়াত মই আসামীক মই গোচৰ কৰিবলৈ উপদেশ দিওঁ. উক্ত নেত্ৰ দিহিঙ্গাৰ লগত উপস্থিত আছিলো. In cross, my lord, চুক্তিপত্ৰ যুৱতী দলে আৰু বিদেশীয়া দলেৰ মাজত হৈছিল. চুক্তিপত্ৰত যুৱতী দলেৰ সহি নাছিলে. Exhibit 2 খন টকা পইচা
Okay, fine. That is why the police did not register a case immediately, requiring the respondent herein to approach with a complaint petition. And then the court proceeded in the matter in a complaint petition. Okay.
That, my lord, the first part, my lord, that question had been put, my lord.
Okay, forget that forcing part. But what about the other part? Parting of the money. Projection by you that you are an agent of Vodafone. That there is no material to deny your this projection. Then so cheating is established. Yes. So what is the material here to have a sympathetic view in your case? Nothing.
That only part that the civil nature since recovery of money, my lord, and the exhibit.
Civil nature recovery of money, fine, very good. But the projection that you made, which resulted in parting of the money, that is 420 established, ingredients established. Because that you did not deny that you never approached her with that. There is a check amount given for
In my lord, 313, I have denied, my lord.
what have you denied? 313, I think you have brought on, you have annexed it.
Yes. I have an page 27. Vernacular, my lord, page 29. I said, my lord, in vernacular, Misa Obhijog, my lord.
Oh, Misa Obhijog is nothing. Where is your clarification? Where is the question put to the respondents that what you are saying? I never approached you. I never projected myself as a Vodafone thing. Nothing is there. And here also in your 313, the first question is you identified yourself as an agent of Vodafone. You have not clarified. 313 has some relevance. It gives you an opportunity to put forward your clarifications. You have not utilized that. Sotyo nohoy, misa obhijog, that will not take you anywhere. Yes, Mr. Amit.
Concurrent
Hmm.
interfere.
Hmm.
They have not made out any case to interfere in those orders, Lordship. And the money which was taken, that is proved, Lordship, through Exhibit 1. Exhibit 1 was never disputed by them, Lordship. Even in appeal or before
Exhibit 2.
Exhibit 1, by which, Lordship, it is proved that I paid money to him. That was never disputed.
Hmm.
And question number 1, it is specifically asked to him that he was the agent and he approached. That part also, Lordship, on the sim. Apart from that, there is nothing on.
Exhibit 1 is what?
Even what is the check?
Check, huh? That's not a receipt. That's just the check. And the bank account was also as exhibited. Seized and exhibited. Yes, Mr. Sharma. Here, gender will not take you anywhere. This is gender neutral. Being a lady will not give you any advantage.
When is also a lady.
No, no. Accused, being a lady will not carry any further advantage. And this is a revision. So until and unless there is any glaring irregularity, I cannot appreciate the evidences. I should not. I have not been able to demonstrate any glaring. Even if I take Exhibit 2 out of the equation, fine. Exhibit 2 is something which happened in the police station. Let us forget that. But the factum remains that you approached, money was parted. 2 years. Yes, Ms. Bora, what do you say?
Convicted the petition.
Were you in behind prison for any period of time? No. Bail all along.
Exhibit 1, he has
Any other allegation? Any other case in the same line against you? Nothing.
My instructional, but I could not communicate that for a long time, my lord.
When was the offense?
10.
15 years down the lane.
has been given and money has.
This is not a forum for getting the amount paid. This is only with regard to the cheating aspect. You're not concerned with the whether the money is paid or the money is not paid. That is Exhibit 2.
Exhibit 2.
That we take it out of the
That,
equation.
that also, Lord, if it was false, if it was under pressure, that is that by in after that also he has not complained before.
406 will not come in. Rightly so, it has been done away with. Okay. Mr. Sharma, I'm sorry. Let us see if we can do something with this sentencing. Reduce it a bit required. Any objection? Because it is up to 7 years. So after 15 years, maybe we'll not put her back because she's been suffering. I'll consider. Huh?
Sentence part may be there.
I'll consider. If it is a case which is entitled for Probation of Offenders Act, I'll give her that. If not, it would be 6 months. That is a wrong legal advice. That is wrong legal advice in the trial court. Any other case against her on discounts? Mr. Ahmed, any other case against her on discount? Because after 15 years, it's painful because it would be putting her into more trouble. It's a great thing to see you, Mr.
Pleasure, my lord.
It's a pleasure is this side. Pleasure is this side, Mr. Day. Always. Huh? See, 15 years are down the lane. She did a act. Fine. But she has been litigating before the trial court, before the appellate court, and before this court. I think that is punishment enough. 420. And it's a compoundable offense. She did not approach. If she had approached, maybe something would have happened. Not today. Not now. Okay, we uphold the conviction. Give her the probation.
Sentence at least 6 months.
I don't think so. After 15 years, I should be sending her to jail. We uphold the conviction, but we free her from the imprisonment. Fine you are paying within a period of 1 month from today. She's already suffered. I think she has got her penalty. Mr. Day, you will be here for some time?
Tomorrow.
Okay. Okay. Huh. Mata, 12 to Mata. Are we, Mr. Talda, you ready? Yeah, 5. No, I'm here. You start. Aha, if required only, Mr. Talukdar will not require, I know that.
I'll do Divya. My lord, what I have found that the entire case of the prosecution, it rests on a motive, saying that the petitioner, he was expelled from the examination for taking recourse to unfair means. And therefore, my lord, he had subsequently assaulted, my lord, the PW2, who was, my lord, the
victim.
invigilator, the victim. So essentially, the entire prosecution case rests on the, my lord, motive of the, my lord, the accused, that he was, my lord, expelled, and therefore the retaliation, my lord. Now, your lordship will see what has happened, what I have found, my lord, prima facie. The FIR was not lodged by the victim himself.
By the principal.
By the principal. Now, principal, in his cross-examination, my lord, he says that I don't know the accused in the cross-examination. He is not our student. He was not the student. Whether, my lord, he will sit in the examination. If your lordship comes to the cross-examination of the PW1, the first line, cross-examination. I don't know the accused. He is not a student of the school.
Hmm.
And curiously enough, my lord, it's the burden of the prosecution to prove the case beyond reasonable doubt. It does not rest on me, my lord. The prosecution does not bring on any record to show, my lord, that he was a student and he had appeared on the examination on 2/8/2005.
Hmm.
No record, nothing.
Hmm.
And Exhibit 2, that is a seat plan. And also interestingly, your lordship will find on record, page
Okay.
16 and 17, my lord, of the trial
Okay.
court records.
Okay.
There are two
You
exhibits.
come to PW2.
my lord.
You come to PW2.
Yes. PW2 says, in the FIR, my lord, in fact, the name of the accused is also different. It is some Joinul Islam. So it may be a case of, my lord, misidentification also. I'm not on that, my lord. I'm not stretching that. But he was an examinee on that date. There is no other, my lord, documents. It is essentially a case of, my lord, documentary evidence.
But the assault, that aspect, you forget the second part. The assault that took place, that has been, he was named by the victim. There were 4-5 persons assaulting him. Only one could be identified. And that is the present. That aspect of the matter is not dislodged in your cross.
My lord, I could not go through the entire, my lord, evidences, my lord. That
What is
respect-
the boy doing now?
If he was a student at that point of time, now from 2005, now almost 20 years have gone by.
Yes, Ms. Bora. Mr. Goswami, what do you say?
If your lordship was the my lord, evidence of PW6, my doctor's evidence, and along with the
There are two doctors here, evidence
doctors,
is
my
here.
lord, yes.
But basically one says a blunt, one weapon is by sharp, others are blunt.
Yes.
And the other one is in that first hospital, then the other one is in
Yes.
the bigger hospital.
Yes.
So he gives up detailed thing.
Yes,
And
because-
that corroborates the evidence of
Yes,
PW2,
because he was referred to the
larger
Women's
hospital.
Medical
Hmm.
College, my lord. There your lordship will find the injury right in the forehead,
Hmm.
scalp part,
Hmm.
chest part,
Hmm.
2 soldiers injured, 6, all are corroborated, my lord. And the more often, my lord, here I
Mr. Talda, were you ever in detention?
by PW2.
Hello?
my lord.
Were you in detention at any point of time?
My lord, in fact, take that. And
Mr. Goswami, was
I
he
will
under?
check that. I'll check. I have not time to all that.
if I,
I don't think so.
6 months and fine, my lord. So it's
my lord, by this
my-
time, your lordship will kindly see, by this time, if he is in some service, my lord, that will affect his, my lord, service career also.
You bashed up a teacher.
No, my lord, that has to be, my lord, that has to be beyond reasonable doubt. I'll, my lord, try to satisfy your
No,
lordship.
the fact that
My lord, what I pray.
that assault part.
My lord,
is
what I
proof.
pray,
Yes.
let me get the, my lord, certified copies. Lordship will make it part heard. Your lordship has already heard. Next week, my lord, Tuesday or Wednesday, my lord, I will, my lord, make my submissions, my lord. Then your lordship will finally decide it. My lord,
I gave
today
you that
I
opportunity.
could not go through it, my lord, because I could not read all the, my lord, evidences.
Today is not the day I gave you. I gave you a week or 10 days back.
I have the documents I have applied, my lord, in the registry. They, my lord, could not provide me. It
even,
was
my lord,
during
we are,
the
we are in the
intervening
worst,
holidays, my
we are
lord.
in the worst
What
side,
is the
my lord.
cause from?
We have to see that be so, my lord. We have to take time on every cases, my lord, because also we hardly get, my lord, 5 to 10 minutes, my lord.
My lord, 9, my lord, I have applied.
All the cases by evidence.
Money receipt and the application is there, man. And I am informed by the filing section that due to the intervening holidays, my lord, it could not be made available.
Mr. Day, you are here. I take the opportunity. We are getting these cases 6 months, 5 months, assault, simple injury. Appellate court, this was by the trial court. Appellate court again gave them bail, considered the matter, rejected it. Matter came up before this court in 2014. This court, considering that, granted bail. Now, after 20 years, would it be prudent to send back the person to jail again?
But I remember my student days in jurisprudence when we were taught the 4 theories of punishment. The retributive theory, as of date, has been given a go by. My lord, it's a reformative theory.
Theory.
My lord, in Tripura, where from I come now,
Hmm.
the jails are not jails. These are called Shodhanagar. They are called Shodhanagars.
Shodhanagars, okay.
These are no more jails.
Reformative homes.
My lord, taking a cue from that, my lord, your lordship knows, Supreme Court has also laid down some, my lord, I cannot readily recollect the citation, but in cases 3 years and below, even where the offences are proved, the man is not made to go to gallows after 15 long years. Instead, my lord,
Probation.
he is probation and fine. Maybe your lordship even extends the fine because yesterday's 10,000, today is 20 lakhs.
20 lakhs.
But that has, by and large.
No, that
Yeah.
is what I was also being following. I just wanted a confirmation of that.
My lord, my lord.
Thank you. Thank you for that.
Thank you.
Mr. Des, think we are accepting probation.
Increase the fine also, my lord. So far, my learned senior friend.
Get the benefit of the probation.
That in an appropriate case we will do. You get the benefit of probation, don't go to jail.
Correct. And that will not prejudice, my lord, his other, my lord.
That we are not saying. Conviction is conviction. Because that is proved. Only because of the delay that is taking place, I'm not sending you to jail. That's all. If you want, you take it, or you argue on merits, my order would be a upholding of that. Because that is established.
But what I want, if I get, my lord, another chance to, my lord.
I think this is enough. Probation.
Correct, correct. Pleasure.
Yes, Mr. Khan, what did you find?
As per allegation, lordship,
Hmm.
the case was registered under section 376 IPC.
Punishment is 354.
Yes, but lordship, no charge was framed.
Need not be. Need not be. There is provision in the CRPC, you can convert that.
No.
If it is lower.
354 is not there in the case.
Need not be. 376 was there.
376.
So why not a lower one? 212. CRPC, read CRPC. That point is gone. That is already settled. Position of law.
Your lordship, there are contradiction in the evidence, lordship, that I have found.
See, the fact is very clear.
My lord.
The accused took the girl from her house without the consent of the parents. While going along with the road, the girl's auntie was met in the road.
Yes.
But the man pulled the girl away. She also, because he calls him Bodeta or something.
Yes.
So there was no apprehension. When the girl was taken to the school veranda, attempt was made. Although it is that no injury or something, nothing is there. So 376% not proved. But 354 admitted.
354, lordship, if your lordship.
And that too a minor girl of 8 years. And her statement is very categorical both before the magistrate and in the consistent.
But if your lordship kindly come to page 20 of the appeal memo. Yes, para 30.
That 376 ingredients not provide, told you.
And lordship 376 2F 511, that was charged. But in the order, only 376 2F, that was ordered.
Fine, that was not proved. But you come to page para 36.
It appears that, lordship, the conviction was made as under section 511. And second, evidence of the PWs, the conclusive which is irresistible is that the accused had taken the victim.
50% of the penalty. Now we will convert that to 354. We are converting that to 354. It's just an attempt to molestation.
My lord, the victim, she has stated in the evidence that that incident was taken place. That incident, lordship, was taken place in front of gate.
And that is a 8-year-old
There-
girl.
There are three.
That slight
Yes, it's
inconsistency we will have to ignore.
Repeating.
We have to ignore. But the factum of the incident, that is clear.
The mother statement, Lordship, that was in the veranda. And in her 164 statement, she has stated that it was little ahead of the girls' high school.
That is a small girl, 8-year-old girl. That, see the trauma she would have been under that. So we
Yeah.
have to.
In front of gate or ahead of the school, that can be, but
There was no injury found in the
No.
private parts. Nothing was there.
The mother found some,
But the medical evidence is not there.
two medical evidence. On that very next day, Lordship, she was examined. There was no injury on her private part. There was no symptom of her of any sexual offense. And in her Lordship, in forensic report, also silent. There was no history of sexual assault.
You have been sentenced to
Five.
5 years.
yes, my lord.
Are available at that point of time.
My
It's
lord.
something which happens within the closed doors of the house. How can you expect there to be somebody?
What happened in the
If there was somebody present, that would have been a doubtful witness.
My lord, what is happened in the
Mr. Day, Mr. Day,
Inside the room, my
498A,
lord.
498A, demand for dowry, torture, evidences are there, subject to what you finally tell me. But there seems to be a gray area with regard to the burning. What do you have to say on that?
My lord, petitioner husband, I'm not fully prepared today, my lord. One thing is that, my lord, the
Mr. Day, you
Evidence-
have this brief from
evidences-
2014.
My
I
lord,
got it yesterday night.
evidences in the.
I got it yesterday night.
My lord, one thing, let me submit, my lord.
Uh,
The evidences what I have, my lord, the photocopy, it is totally, my lord, not readable. That's why, my lord, some problem is I am facing, my lord. If the paper book is prepared or translated copy is given, my lord,
I'm
it is
sorry,
very-
we are not going to do that after.
My lord, it is
14
very
years.
difficult to read the Assamese version. Evidences of the,
You take the original, read from there. I'm giving you the original. I've gone through. Some markings are also there. You go through. We'll take it now. You go through. You have the idea. Read from.
in another date, my lord.
Mr. Day, 2014 matters, these are telling very badly on our High Court.
Only 2-3 days.
We could, with your support,
Only
BAS
2-3
support,
days, my lord.
with the BAS support, 13 we could substantially finish.
My lord,
Now 14,
if I
plus five.
submit my, fairly submit, my lord,
Mm.
medical report says that there is no
20% burn.
Yes.
20%, but
But the smell may not be there.
kerosene, some
Smell may
the
not.
scissors should be there, container should be there, nothing.
Smell of
And the
kerosene.
bag allegation, my lord,
See,
totally bag allegation, my lord.
Mr. Day, the allegation is not vague. It is very specific.
No, my lord.
She said
I-
that she was caught by the first wife. The husband poured. At that point of time, there was a couple.
It is the version.
That is why. Hurry, you did not dislodge it. How will I
It is the
accept
version
your
of
thing?
PW3 victim.
And what is there in your 313? Nothing. No clarification, nothing.
My lord,
Mere denial.
they are to probe in the criminal matter. So far, my knowledge.
They
my
have
lord,
proved it.
I'm so much limited cases in criminal case, my lord. But my lord, evidences shows that, my lord, regarding 498A demand, when demand is made, when it is paid.
You want that when demand was made? Demand was made immediately when the first wife had brought 1 lakh.
When it is, my lord, it is the omnibus, this is omnibus allegation, my lord.
There is not omnibus.
Yes.
There is a time frame to that.
My lord, father says.
Time frame is when you came back from Shillong.
No, my lord.
Yes.
No.
You go through. Mr. Day, you
No, my
go
lord.
through.
That is, I'm
Right?
respectfully disagree with that, my lord. As to-
In cross-examination. To
That's
that
it.
record.
Nothing is there.
My lord, 498A is not attracted here because they failed to establish. This is omnibus statement
Okay, show
made
me.
by.
I'm with you. Show me. These are all tentative views. You show me. I'm
My-
with you.
I'll see, my lord, 498A. my lord.
No, fine. We are with you.
I am not fully ready today because with the old documents, my lord, and I am felt difficult to read the evidences in Assamese version, my lord. So let me
I can't help
translate it, and I may also sometime maybe given to
Hey,
my lord, read the
Hey.
evidences properly, my lord.
hey. Kali ki mana, sir? Kali Birhaspativar, no? Tomorrow, first item.
My lord,
Not more than.
day after tomorrow.
I'm sorry. Mr. Day, 14 matters we are not doing. I'll forget.
At 7.
I can't read twice. I have read it. It's there. Fresh tomorrow. It's because Mr. Day is making a request, I'm doing it.
Well,
I've not done it for others. I'm making a discrimination today.
oblige, my lord.
On the prayer of Mr. PC Day, raised it to list this matter again tomorrow. It tomorrow by slip
Well,
as a top of the list item. But Mr. Day, be very particular with your 498A because as far as tentative view, 498A is established. With regard to the burning, there seems to be a gray area. Try to work on that. Madam has said we had heard the matter. She has given an explanation. Plausible.
but I will
But,
try. I will
but
try, my lord.
you be ready with them. Yeah.
9.
Yes, Mr. Mahmood.
Yes, Your Lordship would say there is no eyewitness excepting the victim. And so far the victim is concerned, he should not be fully, because of the situation that she narrated the story after 3 days to her husband without
See,
telling.
the evidence, that aspect is considered by the courts below. And it is said that there was no other male member in the family. And the Supreme Court also says in a case of sexual assault, a delay of a few days will be not fatal to the prosecution case.
Depend in as per circumstances.
You show me why this she was there with 2 minor kids.
Her husband was at Shillong,
Shillong.
but she could have communicated the matter.
She could have. She did not. That will not be fatal.
There are so many persons, Naresh Burman, Khagen Burman, etc. Hiren Burman, Kaushik Burman, they are not the eyewitness.
I think, Mr. Mahmood, you are not on the track. You should come to the track.
And
there are other ways of looking at the offense.
kindly see page 17, bottom.
Hmm.
There is no eyewitness to the occurrence except the victim. The circumstances under which the occurrence had taken place do not demand that there should be an eyewitness. That is the observation of the court. But my submission is this, my lord, as there is no eyewitness, and of course she was also examined by doctor, and punishment has been given 457, 354, and this is the case of my lord. The year incident happened on. Doctor examined her on that day on 31/2009. Incident happened on 30/01/2009.
Yes.
The incident happened on 3/01/2009. Incident happened. And now we are in 2025. And in this regard, my lord, the various courts has given the judgment that in such a matter, the court should not go on insisting physical punishment, and that is imprisonment, because he is now has become older than much earlier. And in this regard, our High Court has a decision. That is 1996.
So you are on sympathy, not on the merit.
360. I am on 360 because it is said that
not not up to the life imprisonment also. This 360 is applicable even in a offense where it is proved that life imprisonment also. That may be also. So 360 of CRPC did that.
Yes, Mr. Goswami.
And we have certain citations in this regard.
Of the evidence of my lord, victim, my lord, and also my lord, at that on the day of occurrence, my lord, she
See, the delay has
tried.
been explained
Yes.
by saying that the husband is not there.
Not
But the factor is the entire family was there. 3,
And-
4, 5.
they are not the family.
They are family, they are related.
They
Separate houses.
they
Maybe,
Yes,
but
they
they
are-
are related.
and they
If
are-
there
they
was
have
an offense done. And the thing is that their torch was there. His torch
Torch-
fell down there.
it-
Mr. Mahmood has not gone into that
his
as well.
thoughts fell down.
But
and
that torch was not connected back to the, it was not even seized.
not even is seized. my
Seized but not
seized.
connected.
Seized, but not
There
connected.
is no attempt to connect that
Yes.
to the accused.
There is nothing.
And
confrontation,
the victim says that he had broken the door. But I don't find from the other evidences that the door was demolished,
Yes,
broken.
but that is not confronted. I have seen.
So 450,
So that
he
is why
came
my-
and called Bodhi
that is-
outside,
Yes.
right? But the evidence is on the right hand, I suppose. Medical.
Is right hand. Actually, in the
Right hand.
right hand.
And she said left hand.
The day of deposition,
Mm.
but in the FIR, she said the FIR supports the
Left
person of
hand.
doctor, madam. The FIR, it is right hand, madam.
This may be a minor contradiction. Hmm.
They are not
And
dying
my
here.
Incident time of
And
11.
going by judgment, my lord,
1 a.m. your lordship.
every
Daytime
aspect is my very calculating the judgment, my lord. Read, my lord. All that.
Done. Okay. We'll consider.
I have given some citations that if all cases of conviction in minor cases, instead of conviction, the fine should be imposed. That is there, 1996 GLR 35, para 9. I have also given the judgment. 2010 SCC 260, 2017 SCC online. So all this says that in a such type of old cases,
Mr. Mahmood is also submitting to the fact that the
Yeah.
conviction is proper.
conviction, my lord, because my lord, in such type,
Okay, Mr. Mahmood, we'll look into it.
the victim's statement normally accepted.
Dismissed. Or nine, Arrested.
Private respondent.
हाँ,
AR.
नाम गिटा लिख लो उसको.
All right.
That item, decision I want to put, please that, yeah, 2 o'clock, I lots of asked me to. Yes, exactly. Husband, my lord.